The opinions expressed on this program are those of the program host and guests and are not those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Call in with your questions and comments at 340-1590. 340-1590. Now with Ask a Lawyer, here's your host, Attorney Stuart M. Address.
Good morning, everybody. Good morning, Port St. Lucie County, and wherever else you may be listening from.
Worldwide, actually.
Well, that reminds me, Boca Raton. You know, you see these athletes when they do something really great. So I promised. Hi, Mom. All right, now I did my obligatory, shout out. I have one more, actually. This will prove whether or not my paralegal is really listening. Like she's supposed to. I mentioned last week when we were talking about McDonald's,
right?
That I come back and I added a couple things that I had omitted the first week. Mm-hmm. And she was very happy that I mentioned that it was my paralegal who reminded me I had omitted a couple of important facts.
That's what she's there for, right?
Absolutely.
To remind you.
She's there as a backup, absolutely. So the only problem was she was not thrilled. I didn't mention her name.
Oh, okay.
Cheryl, if you're out there, I've done it. I hope we're even now. And if you're out there, which you should be listening, you might want to give us a call and say hello. Not right now, a little bit later. Okay, so as Cliff said in the intro, let's get ready to rumble. The first topic, I think, might just cause some of that.
Okay.
You know, we just finished with Valentine's Day.
We did.
Mine was very happy. Hopefully yours was happy. And Cliff's and whoever else. Mm-hmm. But there are people all over the place.
Not so happy with their Valentine's?
Well, they choose to propose on Valentine's Day.
I did hear a story about that, and I kind of went, why do people do that? That
it's romantic.
Is it? Okay.
Oh, how romantic.
I guess you would
get?
never forget your anniversary that way.
Well, that's a good, that's good. It's not your wedding anniversary, but it's at least your anniversary of your proposal. So they propose, and, whether it's the guy proposing to the girl to the guy, or any other combination, they get a happy yes. Sometimes in public. Mm-hmm. And then the 16th and the 15th, 16th come around, and somebody isn't quite as happy as they were on the 14th. Or maybe it's a month later, mm-hmm. 2 months later. So what happens then?
You give the ring back.
Do you really have to?
No.
Well, I don't know. You sure?
Well, being the recipient of a ring, I would be thinking I get to keep it. You gave it to me. It's a gift.
Oh, not quite. Not quite.
Is it? It's not a contract. It's a gift.
No, it is under Florida law and the law of most states. It is a conditional gift.
Really?
Yes, sometimes gifts do come with strings.
So I have to give the flowers back too?
I don't know about the flowers. Anyway, the short of it is, if you propose and you give an engagement ring, whether it's on Valentine's Day or any other time, and you decide you want to break it off, you're not getting your ring back, guys or gals. It's a conditional gift, but you're the one who broke the condition. So the marriage, which is the condition of the gift, didn't occur because you, the one who gave the ring, screwed it up.
Okay.
On the other hand, if the person to whom the ring is given decides to break it off, that ring comes back.
Okay. Because
they broke the condition, and it's not a gift that was intended for them to keep unless there was a marriage.
So that ring is a binding agreement.
Well, the ring isn't itself a binding agreement. You can always refuse to say, I do. But the ring itself is property, and depending upon who doesn't say I do, it either stays with the recipient or might have to be given back.
So how many people actually go to court over that ring?
You would be surprised.
Okay.
I found a couple interesting decisions when I was looking at this a few days ago in Florida. The primary decision comes out of a 1975 court case. And it talks about what are called heart bomb statutes, which Florida has abolished. Okay. A lot of states have abolished, not all. And a heart bomb statute is a statute that allows you to sue for alienation of affection, things like that. Well, today you really can't sue for those things. So most states have abolished those statutes. However, you had those statutes abolished, and then you had some cases about rings, and the person who gave the ring and somebody else broke it off, they didn't get the ring back. And that led to a whole body of law. And essentially, I'll tell you, there's one quote that I really thought was great. One of the judges from the 1975 case, he explained it this way. The engagement ring's a conditional gift dependent, quote, upon the voyage on the sea of matrimony, end quote. Very eloquent, very poetic. So that's really what it boils down to. There's also, interestingly, a 2014 case right here in our area, so only a few years ago. So these things still do go to court. Now, interestingly, you cannot sue for the value of the ring. You can't sue for money damages. The only thing you could do is sue for the ring back.
Okay, now what if I already took it to the pawn shop and sold it?
Well, that's an interesting question. We're going to play Stump a Lawyer. I didn't find any
And
case.
anyone can call in and do the same, 340-1590.
Yeah, go ahead. Stump me. Let's talk about this. Hopefully none of you out there propose and are having second thoughts. But if you are, give me a call. If there's anybody angry, give me a call. We'll talk about it. That's an interesting, law is nothing but gray. There is so little black and white.
Okay.
So what happens is when there isn't a clear law on something, you go up on an appellate court and you make your argument. The judges on the appellate court start giving you hypotheticals. Well, what if this and what if that? And they try to bring you out really far into a branch until you collapse on it.
Okay.
And that's about as far as your logical argument will go. And from there, law is created. So I don't know the exact answer to that, but let me speculate, which attorneys often do, and then they go back and they do the research. And I would think that if the ring has been sold by the person who broke the promise, then you may have a suit for money damages.
Okay.
But it's not as if you can elect that if the ring is available.
Okay.
Now, when I mentioned that I was going to discuss this at the top of the show, somebody mentioned to me, well, what about, another one of those, what about if I gave my boyfriend some diamonds and rubies that were given to me by my grandmother, and he used them to make my engagement ring. And then I broke it off. It's a very interesting question, too. I would think that in those circumstances, you may still be entitled to keep the ring because the predominant content of the ring is what was yours. But we'll leave it as the general rule. This is what we always have in law. We have a general rule, what's called the black letter law, and then you have exceptions. And
so what we really need is an engagement ring agreement. There should be a piece of paper.
A prenup, that's what's called
There
a prenuptial agreement.
That says, if I give you my grandma's ring and things don't go well, you're giving it back.
It's that's a pretty smart thing to do, actually. The reality is most people aren't going to do that because
they're young.
Well, no,
they're in love.
Oh, come on now. I'm in my I hate to say late 50s, but even I don't think that's romantic. I understand people choosing not to do prenuptial agreements when sometimes it really should be done. Like if you're marrying, it's a second family and you both have kids, and sometimes it's very smart to do a prenuptial agreement. I can understand certainly not coming out with a contract about an engagement ring. But this is...
by the way, here's the paper.
Right. Here, the condition is in the law, but here's a big contract that gives you all
I'll
the
let you
conditions.
see the ring, but first we need to do some
Right.
paperwork.
So, the law is made in the gray areas. And those couple of examples would be gray areas. So, hopefully nobody has a problem. I just thought it might be interesting since we just went through Valentine's Day. And since there are some cases even in our area as recently as a couple of years ago, reported cases. That doesn't mean there aren't other cases that were resolved earlier. There are cases that are resolved on appeal, which means somebody loses a trial and the other party appeals, or they appeal if they lost. So it is something that gets litigated, and I'll be honest, I've never had somebody come in about that particular issue in 30 years, but I can see why. I mean, some engagement rings are pretty valuable.
Here's a great idea, too. You get, like, the simple gold band for the engagement. Something that, if you don't get it back, you don't get it back. And the day of the wedding is when you give the heirloom jewelry. The day of the wedding.
You do the fancy stuff as the wedding band and the plain stuff as the engagement ring?
Well, yeah, the engagement ring's always much prettier than the wedding band anyway.
That's my point. I mean,
Yeah.
if you're going to get the plain stuff as the engagement ring, I don't know, maybe she'll say no.
Or just something symbolic, like a ring out of a gumball machine or something. Just symbolic.
Cracker Jacks?
This is the one, this is the promise ring. And then when we actually get hitched, you get the good stuff.
I don't know how well that would fly. I think in the traditional sense, when the guy is giving the gal the ring, she wants to be blown over by the ring.
Yeah. Well, yeah, so you can go show all your friends. And
needs to be very shiny.
Yes.
Sparkly.
Large.
Hopefully not tiny.
Yeah.
But so, yes, just an interesting thought, I figured, since it was Valentine's Day.
So we've figured out who gets the ring. Who in a divorce, who gets the dog?
Well, I hate to tell you all you folks this because, I now have a 6-month-old black lab, and you begin to love your animals, and I've had other animals, cats and dogs, over my life. And they were members of the family. But in the law, animals are property. And so it is subject to the property agreement.
So they don't have to pack up their little chew toys and go spend the weekend with Dad, or vice versa.
I have seen property settlement agreements that treat the dog as if it were one of the children, and it does specify, because these are either the agreements of the two who are getting divorced, or if you can't agree, it's an issue you bring to trial. And sometimes, if you go to trial, most likely, I think it's going to be awarded to one side or the other because it's considered property. But if you agree as part of your property settlement agreement that he gets the dog every other weekend and alternate Wednesdays, I guess that's something that gets done, I can understand not wanting to never see your dog again just because you're divorcing that
I
woman.
would think that the dog would stay with the kids if there's still kids
That
involved.
does make a lot of
Let's let
sense.
the kids keep the dog.
That makes that does make the most sense, unless the kids hate the dog. You never know. And there are so many other types of animals that who knows? I mean, who gets the hamster? Who gets the snake? I don't know. I don't want the snake.
There, yeah.
I'll tell you that. All right, so. Next quickie topic, which is an interesting one and also very timely, not as amusing. What we're going to do a lot today, subject to the phone calls, is talk about wage and hour law, most particularly overtime.
Yeah, that's
law.
kind of where we left off last week.
Right. We were beginning to start there. And I thought that, here we go. They won't even let me start the topic.
So, of course, 340-1590, the number here if you've got a question or comment. And there we go.
All right. Oh, I remember Bulldog. Hello, Bulldog.
Hello, Stuart. How are you?
I'm doing fine. How can we help you?
Oh, I just want to take it just to a little side twist on your conversation and bring significant others into this and see if there's any, because I know it's not a common law state. And I understand that, but are there anything, rules-wise that say I have to split property with a significant other if we decide we go our separate ways?
Well,
and I don't even want to go on to how you propose to a significant other on Valentine's Day as opposed to, hi, you want to shack up with
right.
me?
I'll tell you, Bulldog, I have one of those cases in my office right now. And it is just as messy as any divorce. And unfortunately, the divorce division of the circuit court, they don't handle it because it's not a divorce. But if you are going to litigate it either in circuit court, which this one looks like it may go there, it's just as if it is. You're going to do it the exact same way. It's just the rules don't apply. So can you force a division of property that's like, 50-50? No, you can't. That only applies if you're married. What happens if it's a significant other, you start looking at whose property really was it, whose property was it intended to be, and you go through, if you can't agree, each item of property.
Now wait a minute.
Go ahead.
Does that involve receipts?
It can. Look, it can involve receipts. It can involve testimony. A lot of times people don't have documents. The two people testify, and the judge decides, well, this one is more credible than the other on this issue. So receipts are wonderful. I love it when my clients have those types of documents. But very often, I know I don't have all my receipts, so I wouldn't expect my clients to. But what you really have to do in those situations is look at the item of property one by one, and when it was acquired, what was the intent? Was this particular item intended to be a gift? You give a gift to your significant other for her or his birthday. Well, that is a gift. That's not a conditional gift. That item is going to remain with them. You buy something together. Now that becomes the more tricky thing when you're dealing with personal property. Then you really have to look at it and you have to negotiate, and if you can't negotiate it out, the court is probably going to look at, something on balance, but it's not a 50-50 split. If you're dealing with real property, which we do have an item of in my current case, that is a little bit easier because if you're both on the deed or the mortgage, then you're both title owners and you have an equal right to the property.
But that would be that way if you were in business partners,
exactly.
or,
if only
your
one
brother or sister.
Yeah. If only one of you is on the deed or the mortgage, let's say, and the other has been paying towards it for 20 years.
Mm-hmm. Can you call that rent?
You can, and probably it would be viewed that way. The property is owned by the person who's on the mortgage and on the deed.
Mm-hmm.
So you probably are going to have a lot of problems with that. Now, in the case that is in my office right now, for some reason, which still hasn't been explained to me, property was purchased by the woman with her funds, and he was put on it as well. Now, property's worth about $300,000. They're breaking up. He wants $150,000.
Mm-hmm.
Is that reasonable or unreasonable?
Well, he was smart to get his name put on the property.
Yeah, he was, because legally,
Yeah.
he owns an undivided 100% share of that property, which really means it's 50-50.
Could she fight to say that he never had the funds to purchase that other half?
No.
Prove your income kind of thing?
Nope.
Okay.
If it's real property and you are on the deed, you are an owner of the property. Now, there may be some equitable defenses that might reduce the amount to which you're entitled and get it somewhat below 50-50, but the reality is you are going to get pretty close, the lion's share of that, just by being on the deed, even if you did no contribution. Mm-hmm. That's just, it's real property law. So, I don't know, have I answered your question, Bulldog?
Boy, well, the advice of the day, it's not cheap to dump a significant
No.
No.
Not that I'm going to. It's just, and some people look at that and like, well, I own the house and this and that and the other thing, and we're not married. It's not a common law state, but it can get into civil court to where, then, basically you're paying lawyers' fees and everything, because if you can't get it out, get out of it on a friendly basis, then, situations like the one sitting on your desk occur.
And this is where mediation is very helpful.
Yes.
Because sometimes it really is not financially worth it for either party to be paying us bloodsuckers of lawyers all this money, depending upon the size of what they're fighting over. Sometimes they're going to end up paying us more than they're fighting over, which makes no sense whatsoever. So if you have a situation like that, two good lawyers representing these individuals will suggest an early mediation and get in front of another attorney that you've picked that's a mediator, hopefully a really good one who knows how to persuade and get people to concede on points, and get the parties to come together so that when you leave that mediation, you have a settlement agreement, it's over, and you can both go your separate ways. Because the worst thing that can happen, it's happening in my current case, is that there are loose ends that require the two to still interact with each other, and then you get precisely what happens in a divorce. Mm-hmm. Sometimes you even get restraining orders.
Yeah, and I've got a question because, in case that ever happened, who gets the cat?
Yeah. Hey,
like you mentioned,
she gets the furniture, you get the trike.
No, the trike goes with me.
That's what I said. She gets furniture, you get the trike.
Furniture, I'll sleep on
Whichever one of you is not allergic to the cat.
All right, well, thank you very much for your time.
You're welcome, Bulldog.
All right,
you take care.
340-1590, the number here at the station. Any questions, give us a call.
All right, so
I would think that the judge would be, judges in these cases, you said it goes to mediation first. It would be like, come on already.
Yes.
You've got things that you made agreements on that you own together. Are you fighting over furniture? Because really the real estate would be the biggest thing, the actual private cars.
And that's the easiest thing actually to deal with. It's the personal items that become complex. And you're right. Mm-hmm. Judges will often look at that if it gets to a trial as, what are you, wasting my time on this?
Yeah.
I mean, you know how many other things I could be doing? I mean, judge is going to deal with it. But very often, in lots of situations, you get to trial on a case that really shouldn't have gone to trial, and judges will look at you and, how much of my time are you planning on taking up?
We're arguing about what?
My very first, when I first moved to Florida in '93, came from New Jersey, and I got a job in Daytona Beach. And I had a beautiful office that overlooked the Atlantic Ocean. Oh, it was wonderful. Mm-hmm. I could see the weather floating in. I mean, it was the best office I've ever had in my life. And the very first hearing they sent me to was in a place, I didn't know it then, called Ocala. And back then you didn't have, all these funny things. I had like a triptych or a map or something. And I'm going through forests and there's nothing there. It's wilderness. And I'm thinking to myself,
am I still in Florida?
Where am I? Why did I come here? And finally I get to this courthouse. And I look at it and I am so impressed. It is a beautiful, modern, large courthouse. Very, very happy to see it. And I go on in, I go to the courtroom that, I have my hearing in. And, I sit in the back like all the other lawyers who are waiting to have their case called. And so what is the very first argument I hear as a lawyer in Florida? It's two people, two farmers, without attorneys, arguing over the ownership of a cow. And I said to myself, And I said to myself, what have I gotten myself into? Is this my future?
So as you drove there, you were expecting like my cousin Vinny when you got there, but the building fooled you. But the first case proved your point.
You better believe it. I remember driving back, and I knew the first thing I was going to say when I got into the office is, do you know what they were arguing about? I'm sure the judge wasn't thrilled to have an argument over ownership of a cat.
But it probably happens all the time, or did back then.
Yes.
Things may be a little different now.
So it's just the way it goes. You try to keep these things out of court. The reality is more than 90% of all cases settle before trial. Mm-hmm. If they didn't, nobody would ever get to trial.
Right.
But sometimes...
Does that mean we sue too much?
Oh, we're going to ask. Probably.
Okay.
Probably. Probably a lot of things that should be settled where there should be a voluntary early mediation don't because of personality and emotions and people not thinking straight.
So really the lesson is deed things correctly.
Well, on real property, sure, that's the lesson. I guess the overall lesson is really, if you're going to be fighting over something where it's the emotions that are ruling you, maybe you have a friend who could be calm and try to help you through it. But once you do go to the lawyers, you're paying a lot of money, and that's the reality.
Now, I would think that could get a really sticky, like Bulldog brought up, the significant other. They are not married. Now, what happens with property that they may share? Because they each may have separate families.
Right. Are you talking real property or
Yeah.
personal
Well,
property?
let's like real estate.
Well, again, real estate, we're going to look at how it's titled. And if it's titled in one party's name,
I mean, even if one or the other would pass away, there would be a tricky way to pass that.
and a significant other.
Yeah.
Yes, I won't name names because I'll get in a lot of trouble. But I'm dealing with that situation. I mean, when I just had my will and trust, and I waited way too long. I mean, I have a kid who's going to be 14, and I dilly-dallied and put it off and procrastinated, doing a will, which was crazy if you have a kid. Should have done it immediately, but I finally did it. And we do have a blended family, and I'm living with my girlfriend, and I had to think about that. What happens if I die and we're all living in this house? What's going to happen to her and her kids? And so we dealt with that some way in the will, or I dealt with it. And
I mean, especially if you have children from another marriage.
Right. And so we talked about it, and we talked about what would be reasonable to both of us, and we came up with a solution, and I put it in my will. So this way, there is some protection.
Being an attorney, you handle divorces but not wills, obviously.
No, I went to an attorney to do my own. First of all, I don't handle wills and I don't handle trusts.
That's funny. Being an
but
attorney,
I still went to an attorney.
Putting off the will, that's kind of funny.
It is. But it's very difficult. I don't mind. We go off topic a little bit. It's very difficult to anticipate your own death, and I did not realize when I went to my attorney just how much you truly had to anticipate it. Not just, okay, just in case I die, can we have a will and, a living trust and all that kind of stuff. No. The questions you are asked require you to make very difficult decisions. I mean, if you have a minor child, who's going to be the guardian of the property? Who's going to be the guardian of the money? Who's going to be the guardian of the child?
Okay, who do you trust in your family that can do all that?
That's really what it comes down
Yeah.
to. If you have an ex-spouse who would obviously automatically become the guardian of the child, do you want that ex-spouse to be guardian of the property? Or do you want somebody else handling the money, which is really what the property is?
Right.
So then you have to, put different guardians in there. And, if there's, money, I mean, when do you want your kid to get the money? You want them all to have the money at 18? Do you want to stagger it? I mean, right. So
No.
all these questions are asked, and you're contemplating your own death.
You're trying to figure out how you're going to continue to make decisions when you're really not here.
So again, I don't do wills, so it's not something that I'm going to get rich off of. But I would tell anybody out there that if you have a child in particular, you got to have a will. I mean, it doesn't matter whether you have a little or a lot. If you have anything that you care about what's going to happen to it in terms of property, real or personal, you need to have a will. It's not that expensive. Simple wills are not that expensive. It gets into a little bit of money if you start getting complex, if you have, stocks and mutual funds and, things like that. But not horribly expensive. I was happily surprised to find out. All right, so now, the one topic that I was going to mention that is timely, by the time we get to it, it may not be timely anymore, which is an interesting topic because it's a lead-in to the wage and hour discussion. We just had this horrible shooting in Parkland, and obviously, I, like everybody else, feel for the families and either lost people or kids or teachers or staff are injured. I feel, frankly, even for those who were worried. When my girlfriend got home that evening, we were talking, and one of the things I said to her was, "Oh my goodness, I can't imagine how the mothers felt on Valentine's Day, wondering about their kids. I mean, it would be horrific on any day."
Mm-hmm.
But,
when we saw the pictures too, we saw the family members standing together where they had them,
right,
the staging area where they had the parents on their phones trying to get information. That there were 14 of those parents whose kids didn't leave that school.
That's right.
And that's so, that touches all of us.
Absolutely. So, an interesting question. You have all these first responders, police, firefighters, paramedics. Do they get overtime? Interesting question. Are they subject to one of the 100 exemptions in the Fair Labor Standards Act just because of the type of position they have and the necessity of sometimes having to work overtime and it not always being a choice of the employer? Are they entitled to overtime, or is this a occupation or a profession that is viewed as one where you do as much work as is necessary to get the job done for the pay that has been agreed upon? Well, there is, for the most part, a simple answer to that question. There are always little exceptions, and if I got into those, I'd probably be here for 20 years.
Yeah, because they just don't go, "It's time for me to quit and leave."
Right.
They just don't go,
As a general rule, they are entitled to overtime. They're not subject to any of the standard exemptions. There are several that are predominant exemptions, the administrative, executive, and professional, which we'll talk about. That's really part of the next topic, that cover more than 90% of all the cases. There are a whole bunch of other exemptions. But so, I looked at it and I wanted to make sure. And it turns out that they are going to get overtime. Generally, they don't qualify for the executive exemption because their primary duty is not management. They don't qualify for the administrative exemption because their primary duty is not performing office or non-manual labor. They don't qualify for the professional exemption because being a firefighter or a police officer or a paramedic generally does not require a prolonged, extended period of advanced learning. Certainly, they do have advanced learning, and sometimes they need in certain degrees or certificates, but it's not of the nature that would qualify for the professional exemption. So I think that we can at least we can rest assured that in situations like what occurred only a couple days ago, and in other situations similar to that, our first responders are at least being taken care of in terms of their wages. If they're required to work overtime, they're going to get paid one way or another. And we're not going to have a situation where, a police department, even if it has a policy because of budgets and whatever, of not permitting overtime, these are situations, just like natural disasters where things change. And our first responders are going to, with only a few possible exceptions, get overtime. And the exceptions, are the type of, where they would normally be subject to an exemption. For example, you have a police officer that is a supervisor, and his primary duty is to supervise a number of people beneath him. Well, no, he's not going to get overtime. He's on a salary, I'm sure, and that is part of his job, to work as many hours as is necessary to get the job done. But 90% of everybody else, the firefighters, paramedics, police officers, if they encounter a situation, whether it's a mass shooting or whether there is a standoff somewhere, I think it's good to know at least
they don't leave and clock out, do they? No.
At least we know they're going to get paid.
But you have to wonder, maybe they are salaried. If they are salaried, then that's on them, right?
Oh, no, my good friend. That is not true. First of all, it is not up to the employer to decide whether you are salaried or not. It is up to the employer to determine accurately whether you are exempt or non-exempt. If you are exempt from overtime, then you're probably going to be paid a salary. It's the logical decision then of the employer. And if you're exempt and you're being paid a salary, then of course you're not going to get overtime. There are a lot of situations in which some employers lose that exemption that they're entitled to, at least for a pay period or two, till they learn better. One of the biggest ones is you're a properly salaried employee, which means you're exempt, and you need half a day off for a doctor's visit, and your paycheck comes and you see that you've been docked half a day. Guess what? For that pay period now, you're non-exempt, and if you work 50 hours, you're entitled to 10 hours of overtime. You're not allowed to dock an exempt employee except in full day increments. So if your exempt salaried employee misses an entire day, you may dock the employee for that day. But you cannot dock for anything less.
So usually when you're a salaried employee, there's like built-in things like sick days and personal days and whatever vacation day. You have that all as like an agreement. And if you've used up all your personal days, and then you owe that employer that day.
Well, that's correct. And
so it kind of all comes out in the wash.
You would be surprised, though. The first thing a lawyer does, first you look to see whether the person who's come into your office is exempt or non-exempt. And if they're exempt, which means you're likely not going to have a case, now you're going to at least look to see, was the exemption maintained by the employer or was it somehow lost by a host of actions?
So what you're saying is if they dock you for a partial day, then they should have to pay you if you work extra.
Yes, that's the law.
Okay.
If you're not only do you get that half day back because you're not allowed to be docked for a partial day, but if in that week you worked 60 hours, you're now entitled for 20 hours of overtime for that week. Now, the exemption comes back the next pay period. What happens, though, is if...
Oh, but now you have your employer mad at you. You might have a bit of a problem.
Money's a pretty big thing. Sometimes that's the one thing it's worth, taking a chance on. If your employer is going to do this not just once in a while and lose the exemption for that pay period, but if your employer is going to do this repeatedly, then the attorney who is representing you is going to make an argument, hopefully, that the employer has lost that exemption, period. That's it. Okay? And that is an argument that would likely prevail. So employers have to be very careful with what they do with exempt employees, just as they have to be very careful with what they do with non-exempt hourly employees. So when we talk about generally, the FLSA, the Fair Labor Standards Act, it provides for two things. It provides for minimum wage and overtime. So if you're not being paid the minimum wage, you can sue and have your time raised to the minimum wage. It doesn't happen as often as the overtime cases. If you're not being paid overtime, and you should have been paid overtime, you're not only going to get time and a half for the hours for which you were not paid, although that is subject to a quite complex calculation, you're also going to get double. You're going to get an equal amount that you're owed in what's called liquidated damages. It's sort of like punitive damages, but it's actually in the statute, so it's not a decision a judge or a jury is going to make. Plus, the reason that attorneys will take these types of cases, which are often very, very small dollar amounts. I mean, can you imagine going to an attorney for a $100 matter that you're owed, having the attorney file a federal action over it? I mean, how's that attorney going to get paid? You're not going to pay him hourly, and if it's a contingency fee, big deal. He wins you $100. Wow, that's really worth it. Well, there's an attorney's fees provision in the statute. And so depending upon how hard the employer fights, if it was fighting and it shouldn't have been fighting, the employer is going to get socked for a very large attorney's fee award. I think we have a call, so we'll go back to that in a second.
And we do have a call.
And I guess it's Warren on 2. How you doing, Warren?
Yes, I have a question. It's not on your subject, but
That's okay.
It's about child support.
Okay.
Do you do anything with that?
Yes, I do. We do handle matrimonial and family law.
Okay. I don't know. Maybe this is kind of strange and unique, but of course I've got children, and back in the mid '80s, I got injured, and I was on assistance, and then eventually got disability. But the child support continued to charge me full support. Even though I only got $98 a month, they continued to charge me $450 a week.
All right, is that in Florida?
No, it was in Michigan.
Okay.
Okay, all right, but anyway.
Go on.
But this went on for years. Okay, but I'm still on disability. Now, I know my child support itself can never, ever go away until it's paid, but the amount is what I'm talking about.
Right.
I mean, they continued to charge me 5 times more than I made. And is there any way that I can do anything about this?
Probably yes. Now, again, I don't know Michigan law, so I can't really give you an opinion on that. I can tell you how it would be handled in Florida. And while each state really can be different in a lot of areas, each state is also very similar in most areas. So I can at least tell you what I would look for and what I would inquire about of an attorney who practices law in Michigan. You would need to file in Florida a petition for modification.
Right.
Those are not really complex things. And again, there are forms, you don't even need to use an attorney. You're allowed to have a modification of child support if there's been a substantial change in circumstances. What you are describing is certainly a substantial change in circumstances. So if you filed in Florida again a petition for modification, then once it's finally heard, which is not always quickly, but once it's finally heard, any decision would be retroactive to the date you filed your petition. So if child support was, let's say, reduced by $200 a week, that $200 a week reduction would be retroactive to when you filed your petition, even if you filed your petition a year earlier. So you would get a credit for that.
Okay.
But just because you're on assistance or somebody takes a job that they're making $30,000 less now than they were before, there is no mechanism, I think, in most states for any change in child support unless you go forward and make an application to have it modified. So that is what I would suggest.
Right now. And again, because I've been on disability, of course, I'm old now and retired. They take so much money from me for that child support that there is no way that I could afford an attorney, or, I don't even have money to pay for an apartment.
Well, again, as I say, there are standard forms, in most states. I know in Florida you would be able to do this without an attorney, just by filling out, a petition for modification and following all the instructions. Again, I can't speak to Michigan, but I can tell you this, that in Florida, and I think in most states, for people who truly are unable to pay for an attorney, there are a lot of resources that are out there. In Florida, I would say, call the Florida Bar or call the St. Lucie County Bar or the Martin County Bar, and you ask, here's my situation. Do you know of any attorneys or any programs that do pro bono representation? They are out there. The average attorney may not do it, or the average attorney may do a couple a year, but there are firms and there are agencies, a lot of them get state or federal funds, that do represent the indigent in all sorts of types of cases. So if you have that situation, and it sounds like you do, I guess I would probably start either, these days you can Google instead of call. I would look into seeking a Michigan attorney or calling the Michigan Bar Association or the Bar Association of the county where you had your divorce and you're going to have to file the application, and see whether or not they can direct you to a program that would provide you with legal assistance.
All right. But
And
by
hopefully-
asking bar, by saying Googling it and asking the bar, I should be able to get someone who may be able to help represent me, or at least give me better information on what I should or should
I
not
really
do.
think that, yes, I think that's true. If you make the right inquiries, and usually you start with the bar, either the state or the local bar. I can't really name in Florida even some of these agencies off the top of my head, but they exist and they're here locally.
Right.
So I know that it's available.
They want more money from me than I've even made in all these years.
And that's a problem. And child support has an understandable purpose. Okay, child support is designed to provide support to the children, but
Right.
it's in the law. Child support is not intended to make the person paying it indigent. So even if you have a decent job, the amount of child support sometimes is reduced even below what the form computations would show, and there are child support worksheets, because it's not supposed to make you indigent. It's not supposed to make you unable, to provide for yourself. And sometimes that means that some logic has to be used, and we depart from the computerized child support worksheet, where you input everybody's salaries and who pays for the insurance, and it spits out a number. Judges, I would suspect in most states, but I know in Florida, are allowed to deviate from that number either upward or downwards, depending upon the circumstances. So if you're... Go ahead.
I haven't been able to work. I haven't been able to work at all since the early 90s. But for whatever reason, I'm not able to communicate properly with them where they want to even work with me.
Well, in that situation, you may have paid a lot of child support that, unfortunately, in your situation, you need not have paid, or you may have back child support obligations.
Right. I agree. There's back child support, but again, they want such a large amount every week, or say every month, that it would take me 6 months to make what they want for 1 month.
Then I think the thing you truly need to do is, investigate it. But what you really need to do, ultimately, one way or the other, is get a petition for modification filed. It's the only way I think that you can be protected.
Okay, and then that particular paper, if I was to call the Michigan bar or something, they could help me, or do I have
Well,
to
they
go-
could get you the forms. They're not going to walk you through it. They're not allowed. But
Right.
if there's a lawyer available, or a program that can provide you legal representation, they'll do that for you. But if you're happy handling it yourself, you can probably get a proper packet, from the Michigan court, just like you can get a packet here from the Florida court.
Okay, because that's a problem. When anytime you deal with a friend of the court, you're on the phone for 3 hours before anybody even will answer or talk to you. So,
Well, that is understandable. It's sometimes a real problem. I agree with you.
and then even for me, the last time I spoke with them, I believe they even wanted money to even send out that information.
You mean the packet? Well, yes, you're right. It's not, again, in Florida, it's not that expensive, but, they do charge for the small claims court packets, for the, the dissolution packets. Yep, there are fees for it. Now, you can also apply, for indigency status so that you're not charged the fee, but then again, you need a form for that, although those aren't forms that they usually charge for.
All righty, very good, and thank you, and I believe you answered my question.
Very, very good. I wish you the best of luck.
All right, and thank you for talking with me.
You're very welcome. Take care.
340-1590. Questions, comments? Give us a call.
All right, so do you remember what we were talking about? This is where I have my little pad, and I should.
We were like overtime and exempt, and who's not exempt. And,
Okay, so let's sort of talk about it.
And the built-in lawyer's fees.
Right. Oh yes, the bill. That's where we were actually. I can't go backwards or I'm going to fall over. The reason that lawyers will take these cases is because of the attorney's fee statute. So that if an employer forces you to go all the way to a trial and all the way through discovery, your client may get, let's say, the $1,000 he may be owed, plus an equal amount in liquidated damages. You may end up making $50,000 or $60,000 in attorney's fees. So because of that, because Congress, when they passed the statute, wanted to encourage lawyers to take these cases, realizing the small amounts, then lawyers take them knowing that very often they will make a lot more money than their clients will. They may get their clients what they're entitled to, but if the employer is going to fight them and the employer is wrong, they can make a lot of money.
Right.
I think we have Rick on line 1.
Go ahead, Rick.
Hey, how are you? How are you today, sir?
I'm doing fine, Rick. How are you?
Good. Listen, I just wanted to put my 2 cents in, and I know it's, I don't want you to think I'm being judgmental or anything, because I'm not. But I just wanted to say this. There is no man in this world that should ever have to be ordered to pay child support for anybody.
Why is that?
If you have children, you should take care of them.
Okay, I understand where you're coming from.
Regardless of whether it works out with you and the girl or not, you have children, you have a responsibility. It's fiduciary. It's also moral. I spent a lot of years in the automotive business, and we used to look at credit reports all the time. This is why I'm calling you.
Sure.
Because a guy would be there wanting to buy himself a $30,000 new truck, and you'd look and he'd be $20,000 in the rear in child support. And you'd think to yourself, my God, this guy can't take care of his own kids, but he wants to buy himself a new truck.
Well,
so that's all. I understand that, you got to defend guys like that, and everybody has their own point of view, and I get it, but it's just my 2 cents.
Well, in general, Rick, I completely agree with you. In the best of all worlds, nobody would ever be ordered to pay child support because nobody would ever be deficient in child support.
And nobody would want to try and resist paying it, is what I'm saying.
Right.
People get involved in hating their ex-wife so much that they forget to love their kids.
You're absolutely right.
And kids seem to become more expensive too once the judge tells you how much you need to pay.
That's true too, but I agree with you, Rick.
And you know what? It's all good. I was married for 23 years. My wife died, unfortunately, but my daughter was 17 when she died. If she was 4, I still would have had the same responsibility. I had to take care of my child.
And to their credit, there are plenty of men out there that do not either, for whatever reason, see their kids or for whatever reasons and pay the child support. There's never a court petition.
And you're an attorney, and I know because of another volunteer thing I do, I work with people that have other problems. Anyway, sometimes I end up in family court with them, and I always tell them this. Please, when you stand in front of the judge, don't say my kid, my kid, my kid. Say our son.
That's a very good point.
Mine, my wife's, and God's. Ours. Because you hear women yelling, my daughter, my daughter, my daughter. The judges don't like to hear that. They just don't.
You're right.
They want to hear our son.
Well, Rick,
that's who it is.
We are out of time.
We got to go to a news break.
Sorry. Anyway, pleasure talking to you, sir.
Thank you very much.
And where's your address? Where's your address? Where's your location in Stuart?
My location is 611 Southwest Federal Highway. It's Suite A. And when she says out of time, she meant it. My goodness, I thought this was the news break. It's the whole hour.
Yeah, we are out of time. Back next week with Ask a Lawyer.
Take care.